Thank you.
My name is I'm the ECZ Leadership Movement. I've come with Dr. Minister David Kalumba, who is the National Chair for the Thank you very much.
Second one, yes, ma'am, please.
Good morning. I'm coming from the Human Rights Commission.
My name is Sandra Smart, Executive Director of the Human Rights Association. Good morning.
Please switch off the other microphone. Yes, thanks. And as you introduce yourself, I implore you to just kindly speak up. We really want to appreciate those in the house. Thank you. The CEO and President for Center for African Network, a civil society organization. Thank you.
Good morning, Masro. This is Makolo from Africanist NGO. Together with my three colleagues, Mr. Dixon Bana, Mr. Sam Edson, and Kabe Nelson. Thank you.
Good morning, everyone. All protocol observed. My name is Benjamin Ndumba. As a Secretary General for New Focus, I have accompanied with John Roche, the National Coordinator, and Jacques Michel, the Chairperson Election, and Mr. Mwangala Mobilization Director. Thank you.
Thank you. Before the next person introduces themselves, I request that the man who introduced herself earlier, could you please repeat the organization that you're representing?
Sorry for that. I was saying my name is Mwangala from Africanist. That is an NGO. And together I'm with Dixon Bana, Edson Sama, and Norton Kabwe. Thank you.
So we really want to appreciate the name of the institution. You said Africanist? Africanist. Africanist.
Sure.
Thank you very much. We may proceed from where we ended.
Good morning, Chair, and good morning, everyone. My name is Abu Banda. I'm here representing CEMISOC, Center for Mass Media Integration and Social Change. Thank you so much.
Good morning. Am I loud enough? My name is Ruth Zulu, Programs Officer at the Zambia Federation of Disability Organizations, Zambia.
Good morning, everyone. My name is Dave Sonzulu. I'm the Secretary General for the Anti-Drug Abuse Association of Zambia. Thank you.
Good morning, everyone. I'm Benedict Mlenga. I'm the President of Anti-Political Violence Association of Zambia. Thank you.
Thank you. Mutuna, I would ask that you begin the introductions on your end. Thank you.
Good morning, my name is Mutuna Chanda. I'm speaking on behalf of the Media Master Trainers. Thank you.
Good morning, everybody. All protocols observed. My name is Patricia Chibiti, and I'm here as a member of the EXCO of the Media Owners Association of Zambia with my colleague
So the first row is full of media master trainers who have already been introduced. Then I will look at Mr. David. Maybe you could go ahead.
Thank you very much. Moderator, my name is David Mvula. I'm the Executive Director for Common Grounds Network. Thank you. Good morning, Chairperson. Good morning, Commissioners. My name is Richard Wani, coming from the Anti-Water Apathy Project. I'm the Executive Director. Thank you. Good morning, Chairperson. Good morning, distinguished commissioners. My name is Elijah Ruvuta. I'm coming from the Foundation for the Democratic Process. I'm the Executive Director.
Good morning, Chairperson, Commissioners, and good morning, everyone. My name is Mwangala Peter from the Christian Churches Monitoring Group.
Good morning, Chair. Good morning, everybody. I'm Dr. Elijah, representing Voice of the People organization.
Good morning, everyone. My name is Angelina Ziamba, representing YWCA, the Young Women's Christian Association of Zambia. Thank you.
Good morning, Chair. Good morning, everyone. I am Charles Richard Rich from the United Party for National Development, European Union. I'm the Lusaka Provincial Secretary. Thank you.
Good morning, everybody. My name is John Kalumba. I'm representing a national chairperson for the Democratic Party. I'm accompanied by Mune Dikani. Thank you very much.
Good morning, everyone. My name is Manu Wenda. I'm the chairman for elections for United Labour Party. Good morning, ladies and gentlemen. I'm Edgar Kamore, representing NRPUP. I'm with my colleague, Gisela.
Good morning, everyone. Legatembo is my name, and the chairperson for mobilization and election. And I have to party known as the National Freedom Funds.
Thank you for your
Good morning. One Zambia. Thank you. My name is Thomas Osatoro, representing the Democratic Union.
Good morning, ladies and gentlemen. My name is Charles. I'm a fact checker for Parents of Zambia.
Sorry, just reintroduce yourself and just kindly speak up when you do so.
Okay. My name is Charles Mangongera, and I'm a fact checker for Panels Southern Africa.
You are a fact checker for the panels. Thank you.
Good morning, everyone. I'm Francesca Benetti, representing MMBP.
Sorry, ma'am.
Good morning. My name is Pesa Matofiri. I'm from the European Center for Electoral Support. Thank you.
Chairperson, members, I think that is the end with regards to our stakeholders who are here present. Allow me to also introduce myself. My name is Matthew Maseka, Corporate Affairs, Electoral Commission of Zambia. At this point, I've got the distinct honor to invite the Chief Electoral Officer, Mr. Brown Kasaro, who will in turn introduce.
Next on Ambassador Mtiti is the Vice Chairperson of the Electoral Commission of Zambia, General Vincent Mkanda.
Good morning, everyone.
Once again, distinguished guests, it is my singular honor to introduce the Chairperson of the Electoral Commission of Zambia, Mrs. Mwangala Zaloumis State Council.
Good morning,
process. Thank you.
Good morning, distinguished stakeholders. I wish to recognize the presence of the representative of the United Nations Development Program, the chief executive officers of media houses. I'm pleased that you are here. Distinguished representatives of political parties, and it's nice for us to know which political parties are here. The Zambia Center for Inter-Party Dialogue, representatives of civil society and faith-based organizations. I've seen a few here, which is nice that we are working this path with you. Members of the Commission, management and staff of the Commission, members of the media who are here right in front of you. It's nice that we are working this path with you and we are always here. Distinguished invited guests, ladies and gentlemen, good morning. I wish to extend a very warm welcome to you all, because I know this week we have been in discussions, engagement on various issues that affect the electoral process. And these issues are very, very important. That we have to talk to one another and work this path in the electoral process. We are here today at a pivotal stage in the electoral process as the Commission prepares for the 2026 general elections, scheduled for the 30th of August 2026. The Commission has convened this stakeholder orientation meeting to sensitize you on the key provisions of the newly enacted electoral process, Amendment Act number 12 of 2026, which was passed into law this past May. Ladies and gentlemen, in July, the Electoral Commission of Zambia appointed the Electoral Reform Technical Committee, and I'm pleased to see that some people who were members of that Electoral Commission are here and they're smiling. Peter, you are there from CCMG. So I was pleased to see that we are still together. Its primary mandate was to review the electoral laws and administrative policies. Upon conclusion of this work, the ERTC submitted its final report to the government on 22nd of April 2025. And this report was circulated, and I'm aware that the cooperating partners had copies, and any political party was welcome to come and collect a copy. In fact, we encourage people to collect these copies. So I'm sure most of the political parties, if they've been following the electoral process, they have copies of that. The report of the ERTC served as a foundational reference during the subsequent review of the Constitution of Zambia, leading to the enactment of the Constitution, Amendment Act number 30 of 2025. Notably, the amended Constitution introduced a mixed member proportional representation system, and this system combines the traditional first-past-the-post method with proportional representation. And this system was in the ERTC report that was represented by many sectors, people from different sectors. These constitutional changes required the Commission to review the Electoral Process Act to ensure full compliance and to implement the new constitutional framework. Specifically, to give effect to Article 47, which introduced the MMPR system and among other articles that were introduced, that were attached. The review process was inclusive. The Commission shared proposed amendments with you, our stakeholders, to solicit your vital submission and your participation in the process. Following this consultative process, the bill was tabled in Parliament and subsequently assented to in May 2026 on the Electoral Process Amendment Act number 12 of 2026. Some of the key provisions in the Act on the PRS system, which you are going to discuss later, and I think our officers will walk you through this. And this is one, participation guidelines, procedures for the participation of political parties in the proportional representation system. The second one, the seat distribution, timelines for submission of party lists and distribution of seats. Third, and as you prepare for the upcoming general elections, with these few words today, they're actually few words. I thank you, and I thank you and wish you a very fruitful discussion as we walk through this process. Thank you very much.
I think we can clap better for our chairperson for those remarks. Thank you, chairperson. Thank you, chairperson, for those remarks and for officially opening our meeting this morning. At this point, we shall go straight into the business that we came here for. We are going to have a presentation on the overview of the Electoral Process Act, which shall be presented by our acting Commission Secretary, Mr. Mukunsa Walia. We can just give him a round of applause as he comes to this podium.
Good morning, distinguished guests. Good morning. The presentation today will be in two parts. I will run you through the first part of the presentation, and I'll speak to the law, the Electoral Process Amendment Act, and the salient provisions. Then my colleague, Mr. Mataskota, will come and present on the formula so that we get both parts. So the outline for the presentation, for my presentation, we'll look at the salient provisions of the Amendment Act, and then we'll also look at the proportional representation electoral system. Now, the way the presentation is outlined is that we've tried to make it as simple and straightforward as possible, so we avoid to quote the actual provisions, but we will explain the provisions. And because if you've looked at the bill, you will note that it has the front part where it speaks to provisions and proportional representation comes in, and there are other provisions that come after that. You will note that the presentation will start by the salient features, then the next presentation will then look at the proportional representation electoral system. So the first things to note under the Act, the Amendment Act, is that the Act has introduced definitions. It has defined campaign period, and the definition now for campaign period is the period commencing after the close of nominations and ending on the day preceding an election. The other definition is the definition of a candidate. So the Constitution defines who a candidate is, but the Electoral Process Act then extends this definition to include a person on a party list for a seat under the proportional representation electoral system in the National Assembly or Council. Further, the next definition is the adoption certificate. So it defines it as a certificate specifying that a candidate is sponsored by a political party for an election. Then it also tells you who must sign the adoption certificate or how the adoption certificate must be signed. So in this case, it provides that a president and the Secretary General, or the president and deputy Secretary General. So you will note that in terms of the allowance, the president is mandatory. The Secretary General, it can be a Secretary General or equivalent, or Deputy Secretary General or equivalent. Independent candidates are exempt from the provision requiring them to provide an adoption certificate. We are still on definitions. The Act still provides for the definition of a Deputy Secretary General as an officer designated as Deputy Secretary General or equivalent office bearer of a party in accordance with the Societies Act. So this means that the record or whoever is submitted on the adoption certificate as Deputy Secretary General, the names on the adoption certificate should correspond with the names with the Registrar of Societies. Now, this is particularly important for political parties to pay attention, because one will be asking, why are we talking about adoption certificate? Nominations have passed. Under the proportional representation system, as we shall see as we go down in the presentation, you will note that political parties will be required to submit party lists. And the party lists will be required to be signed by the very office bearers being defined here. Party list is also defined, and this is a list prepared and submitted to the returning officer. So the returning officer note is returning officer with capital R. If we've looked at the definition of returning officer in the Constitution, we know that the returning officer with capital R is the chairperson of the Electoral Commission of Zambia, and then also a district electoral officer by a political party for purposes of proportional representation electoral system. I will explain this a little bit further so it will make sense. President is also defined, office bearer designated as president of a political party in accordance with the Societies Act. Secretary General, office bearer designated as Secretary General or equivalent office bearer of a political party in accordance with the Societies Act. So we move on from definitions, we come to inspection and objection. One of the key amendments you need to take note when it comes to inspection of the when it comes to inspection of the provisional register of voters is that the law has reduced the number of days for raising objections to an error or omission regarding the details in the provisional register. The law read, it used to be 90 days, it's now 14 days. One would be wondering why this reduction? Well, the 90 days was too long and it led to delays in certification of the voter register, and this is particularly in relation to continuous voter registration. The amended act has also empowered the Commission to determine the period within which the provisional register of voters may be inspected. But remember, the Commission has been determining this period, but the act has made it explicit that the Commission will determine the period within which the provisional register of voters will be inspected. The provision also provides for appointment and duties of a returning officer. The act has further provided for the appointment of a returning officer by the Commission, and the act outlines the duties of the returning officer, which include conducting nominations at the district, constituency, and ward level. So here now we are saying returning officer with small r and o. So these are the returning officers that are manning constituency, district, constituency, and ward elections. So conducting nominations at a district, constituency, or ward level, collating results in the constituency, district, or ward, and declare National Assembly and local government election results. When it comes to particulars or publication of election time, Section 110 provided for the disqualification of political parties that breached the Electoral Code of Conduct. The amended act now has revised or amended that provision providing for disqualification and provided for suspension. So the act has amended the sanction for the breach of the code of conduct by a political party or candidate from disqualification to suspension. As we may be aware, disqualification is a preserve of the courts. So this means that during this campaign period, the Commission may suspend a political party or a candidate in breach of the Electoral Code of Conduct, because it is law now. It also provides for nomination petitions. We are aware we are in the window of nomination petitions following the nominations that the Commission conducted from the 18th to the 22nd of May. So the petitions are being conducted under the rules that have been promulgated by the High Court or the judiciary, and these rules were promulgated pursuant to the provisions under the Electoral Process Act, which have empowered the Chief Justice now to make rules for nomination petitions. It has also brought down the provisions. That are sitting under Article 52 for commencement of petitions in the Electoral Process Act. That was missing, it wasn't there. Then the Act that was missing, it wasn't there. Then the Act further guarantees the right of a person and the local councils. So for National Assembly, the numbers are prescribed in the Constitution. 20 women, 15 youth, 5 persons with disabilities. When my colleague comes through, we will see how these numbers play a significant role when it comes to calculation of seats. For councils, the Act provides that the Commission will provided there. Seat distribution. So the first thing to note is that only political parties that have sponsored a candidate to contest for presidential elections can participate in the distribution of seats under the proportional representation electoral system. So that is very important, and this comes from Article 47, but it is also provided in the Act, the Amendment Act, Act number 12. So only political parties that have sponsored presidential candidates. So in this case, we are talking about, is it 14? About 14 political parties that filed successfully filed in their nominations. Then the Commission will, within 7 days of the swearing-in of the President-elect, distribute the seats under the proportional representation electoral system using the initial ballot. So this is also important. The ballot to be used here will be the initial ballot, and this should be done within 7 days of the swearing-in of the President-elect. One will ask, why is swearing-in of the President-elect? This is meant to also take care of in the event of an election petition related to the President. So that is the rationale. National Assembly and local government seats under PR will be distributed to political parties using the valid votes obtained by presidential candidates at national level. So I want to make that clear. The distribution of seats will be based, distribution of seats to political parties will be based on the valid votes obtained by presidential candidates at national level. So if a political party that qualifies for a seat refuses to take up the seat, the Act empowers the Commission to redistribute the vacant seat to a political party that qualified for a seat using the formula for distribution of seats. So where a political party that qualifies for a seat refuses to take up the seat, the Commission can redistribute this seat to political parties that qualified for a seat. Let's take that, qualified for a seat. The votes obtained by the presidential candidate of the party that refuses to take up a seat shall not be considered during the redistribution process. Let's move to submission of party lists, and I think this is very important for political parties that are participating. So a political party is required to submit a party list to the Commission within 7 days after the distribution of seats. The political party will also be required to pay, maybe before I come to this, now the first thing to note is that where we are, I don't know if it's sitting or where I'm standing now, the Commission is already aware of the political parties that are going to participate in the proportional representation seats because of the following the nominations. So this means that even the political parties themselves are aware. So it means that then the political parties are supposed to begin their groundwork. So parties are required, like indicated, to submit a party list to the within 7 days after the distribution, and the political party will also be required to pay an election fee, that is a nomination fee. This will depend on the number of seats obtained by a political party, as you will see down there. So depending on the number of seats after the distribution by the Electoral Commission, you will then be required to pay nomination fee for those seats. Then a party list submitted by a political party must be signed by, and this is where I said these positions of President and Secretary General or President and Deputy Secretary General are still very critical and very important. A party list submitted by a political party must be signed by the President and the Secretary General, or the President and the Deputy Secretary General of the political party. And remember what I mentioned earlier, in the definition of Secretary General, it gives an alternative or equivalent office bearer. In the definition of Deputy Secretary General, it also gives room for an alternative or equivalent office bearer. But President is mandatory, and these should be people who are registered under the society, registered with the Registrar of Societies, who, if we check the record, it should correlate with what is sitting with the Registrar of Societies. The party list must be submitted to, for National Assembly, the returning officer. Again, I'll repeat, the returning officer with capital R, who is the chairperson of the Electoral Commission of Zambia. Then, for councils, to the district electoral officer for the council, so the DRO or the DEO. Candidates that contested, so these are some of the disqualifications. Candidates that contested the election under the first past the post election shall not be eligible to be on the party list. Please, political parties, pay a particular attention to this, because as we vet the list, these are some of the things we take into consideration. A candidate who contested an election under the first past the post, so when we say under the first past the post, we mean you contested for constituency-based, ward-based, mayoral, you will not be eligible to be on the party list. The party list must be accompanied by a consent form signed by each candidate appearing on the list. So it means that the people who are going to be, if I may use the word loosely, adopted on the party list by the political party will have to sign consent forms where they are indicating that they agree with being adopted on that list. Requirements of a party list. So a political party must submit a party list for each category of the National Assembly and Council as follows. So the number of women seats obtained. So remember, the process is the commission calculates the number of seats a political party is entitled to. Then the political party is requested to submit their list. Now the list that they submit should be the number of seats that they have obtained. So going by the number of seats you've obtained, if you've obtained 5, then you submit 5. So the number of women seats obtained, the number of youth seats obtained, and the number of persons with disabilities seats obtained. So in that, and this applies for both National Assembly and the councils. Then a party list for persons with disabilities shall contain alternates. This is also important to note. A party list for persons with disabilities shall contain alternates of the classes of disabilities. And in addition, candidates on that party list for persons with disabilities should be in possession of a certificate of registration issued under the Persons with Disabilities Act. Very important. We get to the qualifications for candidates on the PR list or PR system. So a person is eligible to contest election under the PR or to be on the list if they meet the qualifications that are stipulated in Article 70 for members of parliament and Article 153(4) of the Constitution for councillors. So Article 70 will give you the requirements or the qualifications for a member of parliament generally. So in short, we are just saying the same qualifications that apply to the same qualifications that apply to give you an idea. If your calculation is it below the age of 35? Is it 18 to below the age of 35 or 19 below the age of 35? So you have to do the calculation there, the math. How old you have to be for you to be on the list as a youth. In terms of processing and publication of party lists, the Commission must process and publish the names of members of parliament and councillors that have obtained a seat under the PR system in the Gazette. So these names will be published in the Gazette, in newspapers of general circulation or any other electronic media within 7 days after the receipt of the list from the political parties. So once the political parties submit a list, the commission will then, once they process these lists to check that these members meet the qualifications that are set out in the law, will then publish these names of the people who have obtained these seats. So where a candidate on the list does not meet the requirements in Article 70 and 153(4), the Commission shall notify the political party to take remedial measures to rectify the party list within a period that the Commission may determine. So if a political party submits a list, and that list, for example, so the political party is entitled to, the Commission calculates this political party A is entitled to 5 seats for women, submits a list of 5 women. Out of those 5 women, 3 are eligible, 2 are not. The law is providing for the Commission to engage the political party and give them a specific period within which to resubmit the additional 2 names so that they are compliant. Now, if the political party, so where the political party fails to rectify the party list within the period specified by the Commission, those seats shall be redistributed to another political party that qualifies. So where a vacancy is created, such a member shall not, during the term of that parliament, be eligible to contest an election or qualify to be on a list under the PR system or hold public office. In addition, a political party that's sponsored, so this is also something to take note. In addition, a political party that sponsored a member of parliament holding a seat under the PR system may recall the member of parliament at any time. So whenever a vacancy occurs in the office of member of parliament, the Speaker must inform the Commission of the vacancy within 7 days in writing, and the Commission will fill the vacancy within 90 days, and this will be done by allocating the vacancy to the next available candidate. But in this case, remember, the list that was submitted was for the number of people that were obtained. So what the law is providing is that the political party will be requested to submit an additional list, and that will be the basis upon which the Commission will fill the vacancy. So if a political party fails again to submit an additional party list for nomination within 30 days, the Commission shall reallocate the vacant seat to a political party that qualified for a seat in line with the formula for distribution of the seats under the PR electoral system. In terms of the council, vacancy is created for councillors holding PR seats if the councillor resigns by 1 month notice in writing to the mayor and council chairperson, the councillor becomes disqualified for election under Article 153. The councillor acts contrary to the Code of Conduct or Code of Ethics provided in Article 155. The councillor has a mental or physical disability that makes the councillor incapable of performing the functions of the councillor, or the councillor dies, and it goes without saying, or the council is dissolved upon dissolution of the council. You will note that vacancy requirements are similar to the ones provided for those holding constituency-based seats and ward-based seats, save for the recall provision. So in addition, a political party that sponsored the councillor holding a seat under the PR seat may recall a councillor at any time. So both at National Assembly and councillor, political parties that sponsored candidates to hold a seat under PR have the right of recall. So whenever a vacancy occurs in the office of a councillor under PR system, the town clerk or council secretary must inform the commission in writing within 7 days This is similar to what happens in constituency-based seats as well as ward-based seats. The Commission shall within 90 days of the vacancy fill with the next available candidate on the party list. So a political party that has no remaining eligible candidates during the term of Parliament shall be requested to submit an additional list for nomination within 30 days of the request. So if a political party fails to submit an additional party list for nomination within the 30 days, the Commission shall reallocate the vacant seats to a political party that qualified for a seat in line with the formula for distribution of seats under the PR electoral system. So I'll end my presentation there, and I'll allow my colleague to come and take you through the formula for distribution of seats. Thank you.
It's very simple. Even as I present, you can even do calculations on your own. So what will happen is after the conclusion of an election, the Commission will add up the results obtained by each presidential candidate. Like you can see on the screen, we have something like a sample, and we have 11 candidates, and those candidates are representing political parties, and those political parties are political party A up to K. Let us pay attention to how the political parties are going to change in the subsequent presentation of slides. So the total number of votes cast is something that we need to pay attention to, because that is critical even as we go down to the other slides. We need to pay attention to the total number of valid votes cast, and I also relate this to the presentation that was just done, that in adding up the valid votes cast, we are not going to consider votes that were rejected. We are not going to consider votes that were rejected. So we are going to carry with us the 1.7 million there. So the total number of votes cast are going to be added up. Then when we move to the next slide, we are determining the quota. Let us not complicate matters. What is a quota? A quota is simply that figure that you are going to get when dividing the valid votes cast by the seats that are available. So if I may ask, if we have 2 million valid votes cast, and those are the votes that we are going to consider. we are looking at 20 seats for women. What would be the quota for women's seats? If we have 2 million valid votes cast and we have 20 seats for women, what would be the quota for the seat for women? Anyone? 2 million divided by 20. What's the answer? Yes, sir. 100,000, yes. So that is the quota. I want us to demystify certain understandings that we may have, because when you look at determining a quota, what is a quota? We should not complicate matters. It's simply dividing the number of seats that are available in that particular category by the total number of valid votes cast. Again, we can go back to 2 million. 2 million, if we go for persons with disabilities, you can divide 2 million by 5. What will be the answer? How many? 400,000, right? So that is the quota. The aim of this session is to ensure that even before the commission calculates, once you know the total number of valid votes cast, you can be able to calculate the quota on your own. So when we look at the slide above, remember we carried 1.7 million as the total valid votes cast. We are simply dividing the total number of valid votes cast by the quota, by the number of seats. So 1.7 million divided by 20, it gives us 86,898. Again, if we want the quota for youths, we are simply dividing 1.7 million by 15, and it's giving us 115,864. And then when we go to persons with disabilities, we are dividing 1.7 million by 5. It's giving us 347,592. So those are the quotas. Now, we had those candidates, the 11 candidates who were participating in the election. We'll simply look for this, for the purpose of this session, we'll just look at women. Once we go through the women calculation, we can be able to calculate for youths and persons with disabilities. Now, this is how they are looking. We are no longer putting the political parties in the order of the way they appeared on the ballot paper because it was alphabetical. Now, when you look at political parties, G is now on top. And then down there, apologies, the other political party is not appearing, but so D down there, there's a getting 0.11 in terms of the quota. So now we focus on the top political parties. So when we look at the women's quota, it's 86,898. That is the quota for women. What this entails is that any political party that gets lower votes than 86,898 will not be eligible to participate in the distribution of seats. You only qualify to participate in the distribution of seats if your political party has obtained votes that are equal to A and E. The rest are not going to participate. Now let us take note of the decimal points, because we are going to discuss something regarding the fractions. Here the wording is complicated, but we can unpack it. What we are saying is that when you look at the figures that are here, we have whole numbers. We have 5, 2, 5, and the next 5, just focusing on whole numbers, going up to 2, 2, and 1, it will simply give us 15 seats. We are going to have a remainder. How many women seats do we have? We have 20. But if we look at those whole numbers, they are giving us how many seats? 15. But those 15 seats have to be distributed in one way or the other. This is the English that is appearing here, and it has been unpacked. But what to note is that a political party that does not meet the quota shall not have its fraction considered. Now we come here. We have already distributed the 5 seats, and we can see that the first and second political parties got 5 seats, the third and fourth got 2 each, then the last one got 1, and we have 15 seats as a total. We are remaining with 5, like we have established earlier on. We need to distribute the remaining and there are 5 political parties that are eligible. But just in case we had 2 surplus seats remaining, we would simply go to the first 2 highest fractions. And when you look at the slide there, we have those surplus fractions. Which one is the highest surplus fraction? Come again? The quota. And the lower the number of seats, like for persons with disabilities, the premium on 1 seat is higher. So we may discover that certain seats that participated in the distribution of seats for women may not participate in the distribution of seats for youths because they did not meet the quota for youths. And certain political parties that participated in the seats for both women and youths may not participate in the distribution of seats for persons with disabilities because the premium then gets higher. In the event that the distribution of seats comes to a tie because of the equal surplus, for example, in here we had 0.63 and 0.62. Now, if 0.63 was 0.62 or 0.63, and then we have 2 0.63s, and those are the last ones to be distributed. There's a tie. We are going to cast a lot, and casting a lot is not new. It's there in the regulations. That's what we use for any other election apart from the presidential election. Now, when we come to the councils, the allocation of seats to the councils, the principle is that the seats are to be distributed based on the formula that is used at national level. And at national level, when you look at the 40 seats compared to the 200 226 seats in the National Assembly, PRR seats are 18% of the seats in the, is 18% of the constituency-based seats. What we are saying is that even the proportional representation seats in the councils should be 18% of the ward-based seats. However, if we are to follow this principle, we may discover that certain councils, that 18% may simply mean one person. And this is what we may look at. So, this is just a sample or just an example. I hope it's visible where you are seated. If it's not, I can tell a little bit of the story from here. We have councils like Lavshmanda Town Council. Lavshmanda Town Council has 6 council ward-based seats. If we are to get 18% of 6 seats, it will give us 1.08 seat. Now, the law is providing that in a situation like this, and when you go down up to the councils that have 19 seats, from 6 ward-based seats up to 19 ward-based seats, these are not giving us absolutely 3 seats if we calculate using 18%. In this situation, it is being provided that a minimum of 3 PRR seats are going to be provided. And this will mean that councils like in Nkema with 8, Mbala with 9, Lunga with 10, Ochpata with 11, Isoka with 14, all these will be able to have at least a minimum of 3 representatives using the PRR system. And this is what I was explaining. So where the formula produces less than 3 PRR seats, the council will have a minimum of 3, and then from there, the formula may be applied. The only council that may even qualify for seats could be Lusaka, if we are to go strictly by the 18%, which Lusaka has 38 ward-based seats. Ward-based seats. At this juncture, I want to thank you. Thank you very much.
Thank you very much, Mr. I think we can clap for both presenters for that exemplary job done. Without wasting much time, I know that this has been a well-debated topic online and in different platforms. So the experts have come, they've explained how this will be implemented, and we are going into plenary, giving us an opportunity to ask questions where there is point of clarity. We have the experts in the house to tend to that. So as you prepare your questions, please just note that go straight to the point and be specific with what you are inquiring on. We shall still go back to introduce ourselves and the institutions that we are representing, even as we ask these questions. So I'll take 3 on my right, then I'll take 3 on my left at a later stage. 3 they responded to, then we'll go to the left, and we shall do it as such until the point the high table guides the chairperson. Thank you. So by raising of hands on my right side, do we have any questions? Oh, wow. Okay, there's a hand behind. I think we can assist her with the microphone. Please, you can stand up and Or you can, better still, you can come and use this microphone here. You can come, you can please come to the front. Here, yes. Mr. Pierre, please help her. This microphone, you can use this one here. Yes.
Okay, so my name is Chandakala and I'm representing Ingoma TV. So my question is, why did ECZ choose to base the PR seats allocation on presidential voters rather than parliamentary or council votes? Thank you.
Thank you. Do we have any questions on my right? Please, sir. I think the microphone is ready. You can ask from there.
Thank you so much, and good afternoon to all of us. So, my name is George Nirenda. I come from the NIZM, a civil society organization.
Sorry, what's the name of the civil society?
NIZM.
NIZM.
NIZM. N-A-I-Z-M. My question basically is on the allocation of seats where there is a tie in terms of the surplus on the decimals. For instance, if there's a tie, let's say from the presentation that was given, let's say there's part A which has 0.62 and part B which has 0.62. Then the criteria is that they will cast lots to determine which political parties members will take a seat. So from the presenter, I did not fully understand how are these lots going to be casted, because all of these political parties are interested to have their members take up the seat. So how is then the commission going to ensure fairness in terms of casting the lot? Thank you so much.
Thank you. Before you sit, sir, please repeat your question, but be precise and be a little bit louder so that we appreciate your question. Thank you.
All right. Thanks so much. My question basically was, in a position where there is a tie, let's say there's political A, which has, let's say 0.62, and then there is party B, which has also 0.62. So from the presentation that was given, the criteria that the commission is going to use at the end is that they are going to cast lots. So in a position where all of the parties, all of the political parties are interested to have their candidates take up the seat, how then are these lots going to be casted, or which criteria is the commission going to use in terms of casting the lot to ensure fairness?
Thank you. That is taken. Mr. George from NIZM. Do we have any? We've got another hand. Please go ahead, sir, and then we shall respond to those three before we proceed.
Good afternoon once again. My name is Ntando Tembo, representing the Independent Party. My observation here on my question.
Sorry, Mr. Tembo. So you said you're Mr. Tembo, which independent party?
I'm representing the Independent Party.
The independent candidate.
Independent candidate under Honorable Given Katuta.
Okay.
Okay. According to this formula which has been presented to us by ECZ, my observation is that there are some some candidates who have been announced to have gone through unopposed from certain regions of Zambia. But now, looking at that situation, mathematically that affects the equation which is being used to do these calculations. So for those candidates who've gone through unopposed, how are the votes allocated to that candidate in an absentia that there was not an actual election which took place? And then, if that is the case, how does this stand to be a free and fair election? Because some people could have failed to actually try and contest due to intimidation by maybe cadres or other factors that's at play. So that is where the question stands, is in how are those votes being distributed for those unopposed? Because at the end of the day, it affects the whole equation which is being used to.
Mr. Tembo, are you still in the topic that we are referring to? Because I think you're combining two different things. Nonetheless, your question is taken, so I'll allow colleagues to pick up the questions. We have 3 questions, if you allow me. We have the first question that came to Chanda Kaila from Ingoma TV. Her question was very precise. Why use presidential votes as opposed to parliamentary votes? Why use presidential as opposed to parliamentary votes? And then we had Mr. George Nyenda from NIZM, a CSO. His question is also on the allocation of seats. In the event there's a tie, and on the surplus there's a tie, you mentioned about casting a lot. He says he was not very clear on how that is done. Maybe you may wish to explain a little bit further in an event we have a tie. Then we have Mr. Tembo, who's representing an independent candidate. He observes that there are some candidates, believe in constituencies and wards, who have gone unopposed. Doesn't this affect then the allocation? And also, he was talking about democracy, so that's where I had to intervene. So please, Mr. Mukunsa and Mr. Scotta, you guide on how you respond to those 2 questions, or if you're going to escalate those questions. Thank you. Thank you. Before you do so, maybe Mr. George, you may wish to explain what NAI means. The CSO, are those initials? Is that a name? What does it mean? Please assist him with the microphone. Yes.
All right. Thank you so much. Okay, so NIZM means the National Awakening Initiative, Zambia.
Thank you. You would have saved us the trouble if you'd said that in the beginning. Thank you very much. So, as earlier asked, Acting CS, may go first. Thank you.
Thank you, Matthew. Chanda Kaela, why did ECZ choose? I think I want to be very specific here. ECZ didn't choose. Article 47 of the Constitution provides that the calculation of proportional representation seats shall be based on the valid votes obtained by presidential candidates. So the Constitution is what has provided for the manner or the form or the way of calculating the seats and where to base that calculation on. Article 47. The other question I want to address is on Mr. Tembo. Firstly, Mr. Tembo, just to note, I'm happy you've given me an opportunity to say something that I didn't say during my presentation. Independent candidates are not party to this process. Please note, this process is for political parties. Again, Article 47 is very, very categorical on that issue. Secondly, the allocation of seats is based on the number of proportional representation seats. So there is no relationship between unopposed and the calculation of seats. What I mean by that is
in the National Assembly. The second one.
Okay.
Thank you so much, Acting Commission Secretary. So for breaking the tie, in determining the proportional representation seats, breaking the tie comes in if there is one seat to be determined, then we are going to break the tie. And how and elective positions except presidential. And when we read in Regulation 48, it talks about breaking the tie as the Commission may determine. And how has the Commission determined? Two pieces of paper will be cut in equal sizes, and then the names of the candidate or political party will be written on those pieces of paper, and those pieces of paper are going to be folded in equal sizes and shall be put in a ballot box. The Electoral Officers Handbook says the ballot box shall be shaken vigorously. I'm quoting the handbook as it says, the ballot box shall be shaken vigorously and then shall be placed shoulder high of the returning officer. Then the returning officer, without looking at the ballot box, shall pick a paper, and that paper that the returning officer shall pick shall then be unfolded and read, and that is how the tie is going to be broken. And the political party whose seat has been, the political party whose paper has been picked is going to be given the seat, and the tie would have been broken. Thank you.
Thank you so much for those responses. But before we proceed, I'll look to the chairperson and the high table if there are any comments from the first set of questions. Chairperson.
I thought I should contribute towards that question, why presidential and not parliamentary? You know, a PR system is always homegrown, and it's a system that reflects either the electoral process or addresses the needs. There are different means of PR, different ways of arriving at the situation. So you have to study the electoral process. You have to study the voting patterns. For example, I think it would be interesting for you to find out in 2021, I think apart from UPND, CF I think was second and third SP. It will be interesting to find out how many votes the president got for CF and SP compared to the parliamentary. Because when you study the electoral process, or when if you've been following, sometimes you get the presidents of the party getting more than the parliamentary. So because of that, you have to identify what is more important, what is a reflection, is for their people to be in parliament or not. So that's a different system altogether. I thought I should mention that. Thank you.
Thank you very much, Chairperson, for that elaboration. I think it's very clear. We shall proceed then with the questions. I'll go to my left. I see there's Mr. David, and then there's another hand. Thank you, Mr. David. We can proceed to, yes, ma'am. Okay, please go ahead.
Okay, thank you so much. My name is Ruth Ngoma from the Commonwealth Youth Council. I'd like to find out, how does the seat allocation process balance democratic fairness with the need to ensure inclusivity for underrepresented groups? And then also, when it comes to participation of political parties and allocation, how is ECZ ensuring that there is inclusivity in the political parties even before they actually allocate them the seats that are available, particularly the youth as well as women and people living with disabilities? Thank you.
Thank you. Thank you. We can have one more hand. I say, Mr. Peter, you can go ahead. Then we'll come back for another set of questions.
Thank you very much and good afternoon. So my question is in reference to section 100.
Sir, please introduce yourself.
Oh, I thought you did. My name is Peter Mwanangombe from CCMG. My question is in relation to section 110, which replaces the word disqualification with suspension, which of course is a decision which is within the realm of the Commission to administer, given the challenges that were experienced with the Principal Act in relation to that particular section. My question is the Commission promulgating any regulations in as far as guiding how these suspensions will be done, and also providing for a graduated sanctions, if you like, so based on the severity of the offense. So how is the Commission handling that in as far as providing for regulations? But also, generally, are there any regulations that will speak to other amendments in as far as providing clarity on the carrying of the amendment? Thank you.
Thank you very much. Those are 3 questions that I think should be responded to before we proceed. And we have Mr. David Mvula from Common Grounds Network, who was asking a question with regards to the lists. Are they as important as those who are elected? That was the first part of the question. And the second part is on the security of tenure. If the political party can withdraw these appointed or these people on the list, how secure is their tenure? And or the last part of the question is, in the event that a presidential political candidate is not successful, do they qualify to be then appointed or put on this list? That was the first question from Mr. David. Then we had Ruth from the Commonwealth Youths. Her question is with regards to representation with marginalized groups and inclusivity with regards to political parties. Is the Commission attempting to engage these political parties that, you know, they are sensitive to the inclusions as they make these appointments? Then we have Mr. Peter Mwanangombe, who observed that there is a term disqualification which was moved to suspension. How would the Commission conduct these suspensions? I see Mr. Mkunsa and Mr. Scott are looking to the high table first to get clearance. Okay.
Thank you, Matthew. The first question is speaking to at what level are members of parliament holding proportional representation seats. They are at the same level as constituency-based members of parliament holding constituency-based seats. So when you look at Article 68 in the amended Constitution Act number 13 of 2025, it prescribes the composition of parliament, and part of the composition of parliament includes members of parliament holding proportional representation seats. You can also tell that they're at the same level with regards to the way in which the vacancy is created, save for the second part of your, I think, second question, where you are asking to say there is the need for a political party to withdraw a candidate. One thing that we need to One thing that we need to note is that these seats are for political parties, and this is emphasized by the law. When you look at Article 47, it talks about seats to be allocated to political parties. So the seats in question for proportional representation are seats for the benefits of political parties that will be calculated based on the presidential results. So therefore, the political party that sponsored a candidate has been given a right under the Electoral Process Amendment Act to withdraw the candidate that they sponsored. You can even tell from the submission of the list. Remember, the Commission will calculate the number of seats a political party is entitled to. Then the political party will be communicated to submit the list. So it's the political party that is submitting the list of the names. So what needs to be noted here is that the way in which the members holding proportional representation seats are coming to parliament is through the political party, differently from those that are holding constituency-based seats who will be elected by members of the public. Then in terms of, I don't know if I've answered your 3 questions. In terms of security of security of tenure, the tenure for political members of parliament is the same. It's 5 years. The constitution has not differentiated, and that's why you will note that even the allocation of seats will be done in a way that these seats will be allocated before members of parliament even assume or go to parliament, so that all the members of parliament will go at the same time. The other question I wish to respond to relates to the issue of inclusivity, how the Commission is ensuring that political parties are inclusive in the way they come up with their lists. So when you look at Article 60 of the Constitution, it actually speaks to political parties and how they are supposed to conduct themselves in terms of intra-party democracy. So the Commission here is of the view that the list that will be submitted will be one that would have been and that would have been come up with by the political party in compliance with what Article 66 or the tenets of Article 60 provide, which is that the political parties must be inclusive in this case. Then you also note that one thing we need to take into consideration is that we still have the lingering issue of the political parties bill. I think that would be the avenue for ensuring that there is proper adherence to intra-party processes, as well as giving effect to the Article 60 that I'm making reference to. Mr. Mwanangombe, your question, and I'm very sure you know, because I know you, sir. Section 110 doesn't provide for the Commission to prescribe a procedure, but in this case, you may also look at paragraph 15 of the Electoral Code of Conduct, which also gives the Commission the powers to take other administrative actions. And also, this is not the first time that the Commission is exercising the power of suspension for political parties. I think this has been done before. In terms of your question on whether the Commission is coming up with regulations, I don't know if that was a general question. Of course, there are provisions in the Electoral Process Amendment Act which require the Commission to come up with regulations. For example, allocation of seats in the council, that will be in the regulation. The issue of the consent form, that will be in the regulation. Maybe the format in which a list should take, that will be in the regulation. So there are regulations that are going to be developed. Thank you.
Yes, as Mr. Mkosa, are you still?
Okay, so the other one is the tenure of office in view of the RICO. I think I've answered this question. The security of tenure provided for is the treatment of members of parliament holding proportional representation seats is similar to those holding constituency-based seats. And in terms of tenure, the tenure provided for those holding constituency-based seats is the same as those holding proportional representation seats. So I've already indicated the rationale for the RICO, and that does not take away in any way the security of tenure for that office. It's still provided that a political party that holds the right to have that seat will nominate someone else to take up the role. And also to note that the rationale here is that there should be no vacancy for proportional representation seats, because these seats are coming to represent the marginalized groups, being women, youths, and persons with disabilities. Thank you.
Thank you very much for those responses. As I look to the high table, there is also the pact to be in clear whether a losing or a presidential candidate that is not successful, if they can be adopted on the list. I'll look to the chairperson.
candidates who take part in first past the post are not eligible to take part in the PR seats. So a presidential candidate who has participated as a presidential candidate and loses cannot be, does not qualify to be included, whether it's a lady or whether it's a youth or people living with disabilities, so they will not qualify. Thank you.
Thank you so much, Chairperson, for the guidance. I see the high table still has some contributions.
Thank you very much, Chair, and thank you, Moderator. I just wanted to add my view on especially on the two issues, inclusivity and equality. The issue of whether those MPs will be equal to those who are elected. I think currently we have nominated MPs who are equal to those who are elected. And these are also more or less like nominated. So the only difference, if you check, is that the nominated are not eligible, I think, to issues of constituency, fuels and other things. I think those are the only differences, but in everything they are the same. So I thought I would give that one. That this practice is not new of nominated. The other issue is about inclusivity. Ruth, I don't know exactly what you wanted to get out of it, whether you talk about regional inclusivity or the categories that have been highlighted, marginalized, because if it is about marginalized, all of them have been provided for in the law. So a political party will have to give a list of the women that have been, their seats on the women, the seats on the persons with disabilities, the seats on the youths. And further, if you read section 36 of the amended electoral process, it even goes further to say that the list, especially on persons with disabilities, should take care of the categories of disabilities, which is an inclusivity in itself. And also, in an event that you are not sure, the law again gives the Commission the right to publicize the publication of the names or the lists. So there you are able to say, oh, there's no inclusivity, or there's inclusivity, and so on and so forth. So if you read again section 36G, will give you the right is given to you when that list is publicized to say, well, I think the women have not been properly represented or included, the youth, and so on and so forth. So inclusivity is actually embedded in the law and not by discretion of a political party. But perhaps the question will be, is it regional? Are all the regions covered? Or the ethnicity covered? Maybe those are the issues now that will come after the publication of the list. I thought I would add on this one. Thank you, Chair.
Thank you, Commissioner Chipenzi, for that clarity and explanation. At this point, we might go for the last round of questions. So if I can see some hands. Okay, I see 3 hands, 4 if anything. So we'll go with, but hands are raising up as we're about to close. Okay, so we start with this side, and then there's one, you'll be the last one, and then we call it a day. Please go ahead, sir.
My name is Benjamin Indumba, and I'm presenting the New Focus Party. My question is, as we are aware that I just want to know which political party will participate in this exercise, because other political party has entered into alliance with other political party. Is it mean that the only front runner political party are the
one of the officers that is in the PR system? We are not going to have that experience. And by the way, we recognize we have accepted the advice that the chairperson gave us to say we need to regularize that with the registrar. However, before we do that, and of course it's not easy to deal with the registrar of societies nowadays, that process might take months, and sometimes it might even go in 2 years. That is our experience there. So please, what assurance do we have that this is not going to recur?
Thank you.
Good afternoon. This is from Citizens First. So my question is concerning the submission of lists for the youth as well as the people with disabilities. About a month ago, I visited the Electoral Commission of Zambia to find out how we should submit that list. And we were guided that for people with disabilities and the youth, the list should be submitted in a zebra pattern, meaning if the first one is male, the next one must be female. And my assumption is the commission wants us to submit that list because that's the way it wants to present that list in parliament, that we should have male and female. Now, if we look at the number of seats that are allocated for the youth as well as for the people with disabilities, these are odd numbers, they are not even. So you will find, if we have 15 youths, you will find there are more males than females or more females than male. And now my question is, in a situation where all political parties use the same criteria when it comes to submitting their lists, for example, if we say they all have male at the first, how will the commission distribute seats equally for male and female for the youths as well as the people with disabilities?
Thank you. Thank you. That's clear.
All right. Good afternoon. My name is Kelly M.S. Macha. I'm here to present Center for Africa Network, CEFANET, civil society organization. My question is on ECZ powers, independence and operations. Expanded powers for ECZ, including suspending political parties or candidates for code of conduct, breaches, appointing returning officers, and handing nominations, petitions. Do these enhance enforcement and neutrality or risk selective application, especially with commissioners appointed by the president? That is me. Thank you.
Thank you. Have we finished asking this? Then we have the last question on my left. Please go ahead, sir.
Good afternoon to everyone, and of course the high table.
So I've got two questions.
Commission of Zambia was quiet. And in my thoughts is that the role of Electoral Commission of Zambia is to make sure that that piece of paper is put into effect. In this particular provision, I've seen that that has been put into an act now, which probably gives Electoral Commission of Zambia more leverage. So what guarantee do we have that this particular provision is going to be applied impartially? Or is it because the violence which we saw during the time of nomination did not meet a certain threshold? Because
sir, please get to the point. You have already exhausted it, just get to the point.
I need to add context to this, because it's very disappointing that up to now Electoral Commission of Zambia is quiet on that violence which prevailed.
Thank you. That is taken. So I'll ask colleagues if you can pick them up. If there's anywhere where you need clarity, I'm always here to assist on the questions. Thanks. So the first questions.
Thank you. So the first question related to the question to I think the question was by Mr. Benjamin. Issues to do with is it just the you referred to them as, is it front runners or forerunners? So as indicated in my presentation, for participation in the proportional representation, for proportional representation seats, it will be political parties that have fielded in a presidential candidate. So it means that all the political parties that have successfully filed in their nominations and have a presidential candidate will be eligible to participate. And yes, a political party that does not win the election can still be entitled to a seat. I think my colleague did show the formula and how the formula can be said to be inclusive, even at that had the highest number of seats. It also considers those with the highest fractions. The question from is it Citizen First related to youths and Zebra. I think, my brother, a month ago when you visited the commission, the act was still a bill. The act now does not provide for the requirement for submission of a Zebra list. The only requirement now is for persons with disabilities. I think what Commissioner Chipenzi spoke to, the issue of alternates in terms of classes. For the other lists, the rationale is that the law from the Constitution itself is already providing a classification. Remember, these seats are for women, youths, and persons with disabilities. So they've already been classified from the Constitution. So there is no requirement for submission of a Zebra list to that effect. Then there are two questions. Firstly, I think the question by, is it Center for Africa Network? The amendment, does this ensure enhanced enforcement? does this ensure enhanced enforcement or risk of I combine it with the question from the last question from our good gentleman. What guarantee do we have that the provisions will be applied fairly? So, firstly, to start with, the issue of appointment of commissioners has always been the same throughout the different governments. So, nothing has been amended in terms of how commissioners are appointed. What we are amending here is the act, and the commission is on record, even in previous general election, where it has taken action on airing political parties. I think that is